matter for an initial appearance. Mr. Benjamin, did you talk to the public defender?
I literally got the paperwork a day before this. So I have not yet.
Let me look. It is an operating while revoked and ignition interlock device tampering. Did you get that criminal complaint?
Yes.
And did you read that criminal complaint?
Yes.
And do you understand those two charges, at least how they're laid out and stated in that criminal complaint?
Yes.
And do you understand those maximum possible penalties? What it alleges that a maximum penalty could be?
Not fully.
Well, not fully. Okay. With the operating while revoked, the state would have to prove that, well, being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway or roadway of this county and state during your revocation period. You drove without a valid license, right?
Correct.
Yes. And so maximum penalty for that could be a fine of up to $2,500 or imprisonment of up to 1 year in the county jail or both. Do you understand that? That's the maximum. You understand it?
Yes.
And with regards to failing to install the ignition interlock device, the state would have to prove that being a person who was ordered to have that ignition interlock device in your vehicle for a set period of time, you failed to install it like you were ordered to do. And the maximum penalty for this offense could be a fine of not less than $150, but no more than $600, or imprisonment of up to 6 months in jail or both. Do you understand that?
I do.
Okay. And do you need me to read anything else on that complaint, like what is alleging you did and how you did it? Do you want me to read the whole criminal complaint? Or
No.
you're fine with that? Okay. Now, are you still on Loon Creek Circle?
Correct.
Telephone ends in 8298.
No.
May we get an updated, please?
218-343-0396.
May the court send you text message notifications?
Yes.
Thank you. Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Is there an offer that can be presented, Mr. Vila?
Yes, Your Honor. The offer is to get his license and we would dismiss the case. Otherwise, it is plea to the operating after revocation for cost only.
So do you understand that offer?
Yes. And just to update if I can, I'm currently
Yes.
working on getting my license. There's a hold in Minnesota and they're not telling me what it is. I don't have any fines. So Wisconsin, I was told I got to do a
The AODA assessment,
yeah, and then
OWI, and follow through
yes,
driver safety plan?
exactly. And so understand all that. Currently trying to figure out the hold in Minnesota. I have went to Duluth numerous times to their DMV, and we can't figure out what the holdup is. They keep telling me to call the St. Paul or go to the St. Paul one, and it's just.
I understand that. I do. And I was just talking to some officers and some other court people from Minnesota. And we were talking this past weekend, we were talking about the issue of Wisconsin and Minnesota fight with this issue. And it's super hard.
Yeah.
And so I understand that. I want you to get your license. Mr. Vila does too. Everyone in here wants you to get your license. We don't want you to have another criminal charge on your record. If you have any, I don't know. Or, to have any further costs other than, if you get your license and have it dismissed. So I'm prepared to give you some time to be able to do that. If you want to get an attorney, great. If you don't, you know the offer and you know what you need to do and the time to do it. If you want an attorney, you can talk to the public defender. We have one here who can go over an application, see if you qualify. That has a fee too, but that's your choice if you want an attorney or you want to just continue to represent yourself for a little bit. Okay.
Okay.
So, but once you get an attorney, if that's what the route you want to go, then that makes it Mr. Vila can't talk to you.
Okay.
Okay. He would have to talk only through your attorney. All right.
May I ask just a quick question?
Sure can.
Is it possible I can get an attorney to figure out what's going on and why Minnesota is not?
You can, but in Minnesota you can. That's super great. And that doesn't help. I'm going to tell you what I think may be an issue. The fact that you haven't done these things in Wisconsin could be your holdup and some ticket or something over there in Minnesota. So my thought is, and this is just my thought, that if you do your AODA, OWI assessment, and you do the driver safety plan and anything else that they say, and Wisconsin clears you here,
Mhm.
I'm gonna say it'll make it much easier to get it cleared in Minnesota.
And so just to follow up on that, Wisconsin's ready to clear me. Minnesota has to,
Yeah, but they're not ready to clear you yet. You
Yeah.
have to do those two things
Yeah.
before they say, okay, you would be good to go to get your license. And you would have those other things. You may even have to get that, because it's a failure to install, get that ignition interlock device installed in your vehicle. And perhaps, I'm not positive, because it depends on the person and their history.
Yep.
That you would have to get the SR 22 insurance.
parents, yes.
So you got to do those things. And I'm going to tell you again, I don't know for sure, but it sounds like if you're not able to get a good answer from Minnesota, that could be your hang up, that you haven't done those things here to clear you here. Once you do those things, you're not going to be cleared to get your license until Minnesota clears you. But at least they'll go, you've checked all the boxes. Now go to Minnesota, get all of those boxes checked, and then you can be valid in both states. Okay?
Yep.
It's a process. I understand that. Let's get a date. And I want you to do those things sooner rather than later. I don't want you to come back here at the next time and say, Judge, I didn't do the AODA assessment. I didn't do those other things. That's really going to be frustrating.
I will look into it as soon as I leave here.
It's about $285, and you can go to Aurora to get that assessment and to do that driver safety plan. So do you have the ability to get that money and do it soon?
Yes.
Because they won't set your appointment until you have that money and you pay it, okay?
But would I be able to do it through my tribe?
Yes, you can do that too.
Okay,
I
and the
think-
only reason why I ask, because it's, I can do a payment.
St. Croix?
Yeah, I could do a payment instead of all the way up front.
Yes, that's good. That's acceptable.
Okay,
Okay? So just do that and do it quickly, okay?
yep.
So let's get another date and give you some time. How about 1 o'clock on August 31st?
Sounds good.
Okay, and so I'm gonna just want to know your update of what you've done here. Hopefully, you've already done the AODA assessment and you've done the driver safety plan. And then we can see, because once you do those things and get that ignition interlock device and the SR 22 insurance.
Yeah.
Yes, 22 insurance, then, we'll see, and hopefully Minnesota will open up and you can get it done. Okay? All right, so we'll see you August 31st, 1 o'clock.
Thank you, Your Honor.
Come get your notice and you're free to go. Brad Collins.
Zoom.
Okay, there you go. What? Nope, you're all good. We will go on the record in the matter 26 CF 82, State of Wisconsin versus Brad Collins. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Collins appearing by video conferencing with approval of the court. I believe you live in Woodman, Wisconsin. Is that correct, Mr. Collins?
Yes, Your Honor.
And that's about 4.5-ish hours away, I think. Is that correct?
Yes, Your Honor.
Have you talked to the public defender's office yet?
No, I just got my paperwork yesterday.
All right, here's what I'm gonna do. I have Miss Hanu, and if she will be so gracious as to, she's from the public defender's office, to log into Zoom, I'm going to send you both into a confidential breakout session, and then you can see if you qualify for a public defender, and then we can see where we're gonna go, because you do have that felony bail jump along with the operating while revoked, okay?
I do have a public defender down here already, so I'm pretty sure I'll
It's
qualify.
different. You need one here.
Oh,
You need
okay.
one in my
Okay.
county. All right, so.
Okay.
Mr. Vila, is there an offer right now that could be presented even though we do have a felony?
There is, and this would require some potential cooperation with Grant County, which is where his open cases are right now. We'd be open to dismissing and reading in this case entirely to that one because he has a pending OWI 7, 8, or 9 right now. Or he can plead to the OAR for costs and wrap it up here so he doesn't have to worry about it.
All right, so Mr. Woodman, apparently you have bigger fish to fry down in Woodman or whatever county you're in. What county is that?
Grant County.
Grant, okay, I think Mr. Vila did say Grant County. So you have bigger fish to fry in Grant County, but here's the deal and here's the offer. I don't know what's gonna happen in Grant County, but I'm gonna tell you, I'm not gonna give you, I don't know when you have, how far in the process you are in that case in Grant County. I don't know if it's in the beginning. I don't know if it's in the end. I don't know if you're pleading to a charge. I don't know if you're going to jury trial, but I am going to tell you, and I'm going to be open and honest. This is not going to last. I will not continue this for a very long time. Even though the offer is that this can be dismissed and read in if you plead to something in Grant County or something like that. Okay. But I'm not going to give you that much time to be able to do that. This will be set for trial, or the offer is plead to the charge for costs. All right. And to dismiss that felony. So it would be, the offer is if you're convicted or plead to in Grant County, I'm going to give you, that is a timeline here with this court. This will be dismissed and read in. If you wish to plead to the operating after revocation, the misdemeanor, and pay costs, the felony will be dismissed. And then you won't have anything to worry about in Burnett County case anymore, okay?
If we could do that.
Well, I'm gonna send you in with Ms. We will go on the record in the matter 26 CT 25, State of Wisconsin versus Benjamin Anderson. The state appears through Assistant District Attorney Jose Vila in person. We have Miss Emma Hanu in person. Mr. Anderson appears by video conferencing. Mr. Anderson, off the record, the court asked if you wanted to be here in person for the initial appearance, correct? And you said no?
Correct.
So video appearance is okay, and you want to appear by video for this hearing, is that correct?
Yes.
All right. This is an operating while revoked. Ms. Hanu, have you had an opportunity to review the criminal complaint with Mr. Anderson?
I have. We would acknowledge receipt and waive any formal reading.
Not guilty plea?
Yes, Your Honor.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you still on 15th Street?
Yes.
Telephone ends in 1614?
Nope, I updated it 3939.
So is it 566-3939?
Yep.
Okay, 566-3939. All right, may we send you text message notifications?
Yes, ma'am.
All right, so this is a case where I'm going to ask, is there an offer that can be presented for this matter, Mr. Vila?
Yes, Your Honor. It would be to get his license and dismiss or plea for costs.
All right, so the offer is to get your license and the matter will be dismissed, or plead to the charge for costs. Mr. Anderson, are you in the process of getting your license?
I was until I got in here.
Okay, so what is it that you have to continue to do?
I have to do the AODA assessment and one other class from what I was told from the DMV.
Okay, and do you need an ignition interlock device or anything like that?
Nope.
Okay, all right.
This is the point where the hearing becomes about much more than the charges themselves. Judge Melissa R. Mogen slows the process down to make sure the defendant fully understands every constitutional right before making any decision. Instead of pushing for a quick resolution, the court emphasizes the importance of consulting with a public defender and carefully considering the plea offer. That approach reflects a key principle of the justice system. Informed decisions matter just as much as the final outcome. If you are facing misdemeanor charges with a possibility of avoiding more serious consequences, would you accept the plea offer immediately or speak with an attorney first? With that explanation complete, the hearing moves towards scheduling the next court date while leaving the final decision in the defendant's hands.
This is a Mr. Schmidt case. How long is your sanction?
It
August
was
2nd.
August 2nd?
Yes.
Okay. August 2nd. So you will be out, and when you're out, you're gonna try and get going quickly and get that AODA assessment and all of those things?
I'm currently in kind of a hole, so it's gonna be a month or two before I'll have any money available.
So I'm gonna give you a little bit of time after you're out of custody. However, I want you to be here early so I can know if you have the money, if you've paid the money, if you've done the assessment, where we're gonna go from there. So Ms. Hanu, can you do September 10th,
I'm free all day, Your Honor.
9:15?
And if you're out of custody, would August 10th at 9:15 work for you?
Oh, September.
September 10th?
Well, and I love that you asked, but he doesn't get a choice unless he's having surgery or something like that. So September 10th at 9:15. Okay, Mr. Anderson?
Yes, ma'am.
All right.
You're all right?
Yes.
No, after, we'll go off the record.
All right. Okay. Thank you. We're adjourned as to that matter.
I was going to say, I also have Mr. Corbine who's on the Zoom.
What?
I also have Mr. Corbine who's on the Zoom.
Excellent. All right. Okay. We will go on the record in the matters 26 TR 427, 26 CF 86, 26 CT 28. No, that's Walter. So we just have 26 TR 427 and 26 CF 86. State of Wisconsin versus Maurice Corbine. The state appears through Assistant District Attorney Jose Vila in person. We have Emma Hanu, defense counsel, appearing in person. Mr. Corbine appears by video conferencing in custody in Burnett County Jail. We're set today for an initial appearance and an intake on the ticket matter. Ms. Hanu, were you able to go over the criminal complaint with Mr. Corbine?
I was, Your Honor. We would acknowledge receipt, waive any formal reading, enter a not guilty plea to count 2, request a preliminary hearing on count 1, but waive time limits.
Not guilty pleas will be entered on all matters. Well, and the felony will have a preliminary hearing. Are you still on Feather Drive, Mr. Corbine?
Yes, Your Honor.
Telephone ends in 4718.
Yes, Your Honor.
May the court send you text message notifications of any upcoming hearing dates?
Yes, Your Honor.
All right. So with regards to this matter, we need to get preliminary hearing, and you said within time limits?
We would waive time limits, Your Honor.
Waive time limits. I do know, I think he filed a request to be heard on bond.
Yes, Your Honor.
That will not be today, but I can set a preliminary hearing with that, and I can do it fairly early, I think, or try to, if it works. CM 60, 26 TR 319, State of Wisconsin, County of Burnett versus Jamie Den. The state appears through Assistant District Attorney Jose Vila in person. Ms. Den appears in person without counsel. We're set today in this matter for initial appearances. Ms. Den, have you spoken with the public defender?
I have not.
That may be something that you want to do. Is that correct?
Yes.
Before we even go anywhere down the road, we even do an initial appearance. Is there an offer that can be presented?
For Ms. Den, yes, Your Honor. The offer would be to do a 12-month deferred on the obstruction, AODA as a condition of that, no new crimes, in which case everything would be dismissed at the end of it.
All right, so here's what's going on, and then so you know all of the things, and you can wrap your head around if you want an attorney, which isn't, it's good. You should talk to Ms. Panu after this is done. So if you can hang around just for a little bit and talk to the nice public defender that I just sent into a breakout session with the person on Zoom and see if you qualify. And then,
Well, did he say no, same, or similar, and then it dropped off my record completely?
here's what he said. It would be a deferred judgment of conviction. That's the offer.
So
Correct.
deferred means if it gets put off. And if I don't get same or similar within a year, then it's dropped off.
You don't break any laws.
I'll
Traffic
take
laws
it.
are fine.
I don't need to talk to, I'll take it.
Don't want to talk to
No.
to a lawyer. Here's what I'm gonna do, though. So do you understand, did you get that criminal complaint?
I did.
And you can read, right? You understand the
Yep.
English language?
Yep.
And you read that whole criminal
Yep.
complaint? And you understand what's alleged in those charges and those maximum
Yep.
penalties?
But if it's no same or similar and I don't get in trouble,
I'll go over that in a second. So, but you understand everything that's in that criminal
Yes.
complaint? Do you need me to read anything to you?
no.
Not guilty pleas are going to be entered on your behalf right now.
Okay.
You would be entitled to a jury trial. You would be entitled to a speedy trial, should you request one, okay? You can talk to a public defender. If you don't qualify, you can apply for a court appointed at your cost or get your own private attorney. But here, this is the offer from the state. It would be like a contract, okay? You enter into a contract, which is called the deferred judgment of conviction. And you would plead to the resisting or obstructing an officer, a misdemeanor, and the other one would be dismissed and read in. And that charge would kind of hang over your head for 12 months, and it would have certain conditions. It would be do that AODA assessment with Aurora, and follow any recommendations and provide that proof to the district attorney and to the court within 90 days of entering that agreement.
So it would still linger on my record?
Not
Is that
on
what
your
you're saying?
record. It kind of, it's just like hanging out there. And after a year, and let's say that you don't do anything else, you don't get another possession of drug paraphernalia charge, and you're just staying all well and good, and you can get traffic tickets. That
Right.
doesn't count, because that's not a crime.
Well, I mean, I would rather plead not guilty, but if it's only a year, I mean,
See, and that's why I want you
I
to
don't
think
wanna, I don't wanna be here. It's not my charge, but I don't wanna fight it if it'll get off my record is
Well,
where I'm going.
And it would technically, if you stay good and do all those things for,
Which I would because it wasn't my,
and here's the thing, you can apply for a public defender, and that's probably a good idea,
okay,
because then they can go over this document, explain it to you, like, you know, I'm trying to explain it to you, the step by step.
Right.
I can't give you legal advice. All right. I can't say this is good for you, you should probably do it, or this isn't good, or you should go to court because I heard that you said it's not my charge.
right,
But I don't know those things. And
Right.
if you are not guilty and you want to continue and, you know, have a jury determine that you're not
Right.
guilty, that's your right. All right. So what I'm going to do is I'm going to set this, the not guilty pleas have been entered. I'm going to set this for a status for a little bit, give you probably a month or so.
okay,
What you can do right now is Miss Hanu is seated right back there.
okay,
I do have her other client here, and I do have to get through other 10 o'clocks. Yes. Oh, where's Joel?
He's in the conference room.
All right, so you can go speak with Mr. Flisky,
okay,
who is a public defender in our little conference room. Go over the application, see if you qualify. And, you know, if you do, it's good to have an attorney, but and he can even explain what a deferred judgment of conviction is.
okay,
All right, so I'm gonna set this for a little bit down the road, and let's say that you want to accept the offer and do it, you would have to let the state know, Mr. Vila, if you don't have an attorney, or your attorney would have to let them know prior to this next date. But if you wish at that time to say, you know what, Judge, I want to accept that offer, I want to do that deferred, we can take care of it that day,
okay,
okay?
sounds good.
Problem is, the earliest I can get you in is September 28th. Is this something that you really want to try and get taken care of sooner rather than?
I
later?
mean, just so it get, I mean, I just want it done and over with it, you know?
Yeah,
If it's not gonna, I mean, I have kids in school, I don't need that on my record is where I'm
Well-
going. That's the only reason, and,
but you do understand that you would be pleading guilty to the charge, but it's hanging over your head for 12 months. If you do nothing, everything's great, it gets
Right.
dismissed. So, but again, that's why it's good to talk to a public defender, and to see if you qualify, because you have to make that choice, and
Right.
you have to understand.
I mean, I'm not a person that gets in trouble. This happened a long time ago
And
with me.
I know.
Okay.
I know, you're not here, you're not doing those things.
So I'm,
I understand your dad and I understand those things, but that's not you,
right.
right?
I just don't want, I mean,
I get it. I understand completely. And so I want to make sure that you get to be heard and you can get this taken care of earlier if that's what you want to do.
I mean, it doesn't matter because even if it's deferred from that day, I mean, okay, so a year and a half, I mean, I'm not going to get in trouble, so I don't have to worry about that.
And I understand that and I get that. So, I mean, I don't see you here other than for support of other people, right?
Right.
And so, and every time you've been here, you have been polite and respectful and, you know, when you're saying your piece.
Right.
So I understand all of those things. I have to put it on a Schmidt week.
It's fine, Your Honor.
I can do August 27th at 9 o'clock.
Okay.
And again, I will set it for the whole half an hour, just in case. I will give you enough time in that slot that if that's what you wish to do, we can get it done and resolve that day.
Okay.
All right. But you're going to have to, or your attorney, if you qualify, is going to have to let the state know well in advance that's what you want to do.
Okay. So, like let's say I end up moving back to my hometown. I mean,
Where is
it's
that?
Minnesota.
That's fine.
Okay.
It's still fine.
As long as I talk to someone and let them know.
As long as you let the court know.
Okay.
All right.
So they have
and
an
I
ad-
guess the state will know by letting the court know of change of address.
Okay.
All right. That's fine. This isn't probation.
Okay.
Okay. But still, it still carries over to Minnesota that if you get charges over there, you do whatever.
Right.
Then-
They'll come back on my record. Right.
But again,
Right.
I know what you're saying and I feel and understand what you're saying. Okay.
Perfect.
But yeah, you can move. So August 27th, 9 o'clock, come get your notice, go to the conference room, talk to Mr. Flisky, see if you qualify, and he can briefly go over a deferred judgment of conviction. And then we should be good to go and we'll figure out what's happening on the 27th. Okay.
Okay. Perfect.
All right. Thank you.
She's going to print it out.
What? Yes, she's printing it out. Mr. Flisky, this nice lady, Miss Den, she needs to talk to you and go over something. Mackenzie Frazee.
Judge Melissa R. Mogen concludes the hearing without requiring an immediate plea, choosing instead to ensure that Mackenzie FRZY has sufficient time to understand the legal process and obtain legal representation if desired. The court enters not guilty pleas on the defendant's behalf, explains the state's plea proposal, and schedules a future court date so the defendant can speak with a public defender before making any final decision. The proposed agreement would reduce the primary allegation to an OWI first offense while dismissing and reading in the remaining charges, but the judge repeatedly emphasizes that the decision must be made knowingly and voluntarily after understanding every available option. By taking this approach, the court balances efficiency with protecting the defendant's constitutional rights